Hello everyone, I'm attorney and professor Kirk Angel, and I want to welcome you to the fifth in our mini lectures involving topics in employment law. Today we're going to be discussing the Americans with Disabilities Act, sometimes referred to as the ADA. But before we discuss the Act, I want to remind all of you that this information is provided for educational purposes and is not meant to be legal advice. If you're facing a serious legal issue at work, I encourage you to contact an attorney who is licensed in your jurisdiction. With respect to the Americans with Disabilities Act, which I said is often referred to as the ADA, it's important to keep in mind that it is something of a quirky statute, and it's a little different than some of the other federal employment discrimination statutes. First, the ADA applies only to 15 or more employees, similar to Title VII of the Civil Rights Act. And the ADA, in general, prohibits discrimination against employees who have disabilities. However, in the ADA, there's actually three definitions of disability. First, an employer is prohibited from discriminating against an employee who is substantially limited in a major life activity. So if the employee has a major life activity, seeing, eating, thinking, concentrating, sleeping, something that we all do every day as a part of living, if that person is substantially limited in one of those major life activities, the employer is not allowed to discriminate against that employee simply because they have that disability. The ADA has a second definition, and that definition is an individual who is regarded as having a disability. So in other words, if the person is not substantially limited in a major life activity, but the employer believes that they are limited in a major life activity and then takes action against them because of that erroneous belief, that employee is protected under the ADA as well. And finally, the ADA protects employees who are not currently disabled, but at some point in the past were disabled. They were substantially limited in major life activity, although they no longer are. And the employer finds out about that. They find out about the employee's record of a disability, and they take action against the employee due to that. If an employer takes action on any of those three bases against the employee, then that would be a violation of the ADA. It's very important to remember when we are discussing the Americans with Disabilities Act that the definition of disability is very peculiar to the ADA. The definition that the ADA uses is not the same definition that you might find a doctor using, or that you might find the government using when they are facing Social Security disability cases, or that you and I would use in everyday conversation. It is one of those three definitions that I just provided to you, and the employee will receive protection only if they are covered under one of those three definitions of disability. It is important to remember that the Americans with Disabilities Act does give one type of protection that our other federal discrimination statutes do not. And that is that the statute requires an employer to provide an employee with a reasonable accommodation. That reasonable accommodation, if it allows the employee to perform the essential functions of their job, is required of the employer. So the employer has a duty under the ADA to accommodate that employee. They have an affirmative duty not only not to discriminate, but also to provide the reasonable accommodation to allow the employee to perform their job. Now, the accommodation must be reasonable. The employer cannot be required to go to unreasonable lengths. For example, expending large sums of money to assist the employee doing their job, substantially rearranging the way that the employer does its work. Those things are not required. But as long as the accommodation is reasonable, then the employer is going to be required to provide that accommodation. I want to point out that there is one provision of the ADA that protects all employees, and that is the ADA requires employers to keep their employees' health information private. So if an employer receives an employee's health information, they are required under the Americans with Disabilities Act to keep that information private. Now, many people think that HIPAA covers that. HIPAA does not, in general, cover the employment relationship. It is, in fact, the Americans with Disabilities Act that covers that. Remember that the ADA, being a federal discrimination law, if you want to proceed under the ADA, you must file a charge of discrimination with the EEOC or an appropriate local or state agency. You have a short time in which to do that, generally 180 days. In some circumstances, in some states or some agencies, you may be given 300 days to do that. However, you should remember that you have a short period of time in any case. I'm Attorney Professor Kirk Angel, and thank you for listening.